3 million pages of evidence, thousands of unsealed flight logs, millions of data points, names, themes, and timelines connected. You are listening to the Epstein Files, the world's first AI-native investigation into the case that traditional journalism simply could not handle.
Welcome back to the Epstein Files. Last time, we walked through bail hearing. Today, we are following Signy indictment through the documentary record, so the timeline, decisions, and institutional failures are clear. As always, every document and source we reference is available at epsteinfiles.fm. So start with charges filed. That is where the paper trail becomes specific and testable.
Exactly. That's the anchor document. We have to start with United States v. Jeffrey Epstein, Indictment 19 CR 490. It was filed July 8, 2019.
And this document, it's what transforms everything. All the speculation, all the civil cases, it turns it into concrete federal charges.
It's the point of no return for the justice system. So if we open the document itself, you see it's built around two central counts.
Right. Count 1, sex trafficking of minors.
And count 2, which is maybe even more important from a legal strategy perspective, is conspiracy to commit sex trafficking of minors.
It's a concise document, really, for something that covers so many years of alleged activity.
It is, and that brevity is, it's tactical. Look at the forensic detail. The time frame they specify is 2002 through 2005.
Just those 3 years.
Just those 3 years. And that's not an oversight by the Southern District of New York. They're boxing in the time frame to the period where they have the absolute strongest, most corroborated evidence and witness testimony.
So they're building the case on the firmest ground they have.
The firmest possible ground. It also helps them navigate some of the statute of limitations issues.
Okay, and then there's the geographic scope. It's laid out right at the start.
It is. The indictment cites locations in Manhattan, New York, and Palm Beach, Florida.
That interstate element is what makes it a federal case.
It's the hook. Without alleging that he induced victims to travel between those two residences across state lines, this could have just remained a state-level issue. The federal jurisdiction hinges on that movement.
So let's get into the mechanics of it, the manner and means section of the indictment.
Right. This is where the prosecution lays out the repeatable pattern, the system. They describe what they call a recruitment mechanism.
The pyramid scheme.
The pyramid scheme. That's the term they use. The allegation is that Epstein would pay his victims to go out and recruit other victims, often their friends from school.
The document is very explicit on the money. It says he would pay a victim, often a minor, a few $100s for what they called a massage.
But then he would offer them more money, sometimes double, to bring in a new girl.
It weaponizes their own social networks. It turns victims into recruiters.
And it provides him a layer of insulation. He's not the one on the street approaching girls. It's a friend approaching a friend saying, hey, you can make a few $100s. It's easy.
And the indictment tracks the language they use, this massage euphemism.
Yes, it documents how that word evolved. Potential victims were told they would just be giving a man a massage, nothing more.
But the filing states that during the session, Epstein would undress, direct the victim to perform sexual acts, and the massage became the crime itself.
It's a documentation of a verbal bait and switch.
And the payment trail is what makes it a trafficking charge, not just an assault charge.
Exactly. The indictment repeatedly cites the cash payments. Hundreds of dollars in cash, handed over right after the encounter. That establishes the commercial nature of the act, the quid pro quo.
It's a transaction.
It is. And because the payments were made to minors, any argument about consent becomes legally irrelevant.
The document also refers to minor victim 1, minor victim 2, and so on.
And that's significant. It tells you these aren't just abstract allegations. It signals to the court and to the defense that the prosecution has specific corroborating witnesses ready to testify to these exact events. They have the people behind the pseudonym.
Okay, so that's the indictment. It lays out the human testimony side of the case. But charges need physical evidence.
They do. Testimony can be challenged. Physical objects are harder to explain away.
And for that, we have to turn to the bail memorandum, also filed on July 8, 2019. This is where we get the details from the raid on the Manhattan mansion.
The search warrant execution at 9 East 71st Street. The details in this memo are, they're critical to understanding the prosecution's mindset.
Specifically, the inventory analysis, what they found.
Right. They found a locked safe, a large one. And inside, the document lists, and I'm quoting, huge amounts of United States currency.
Stacks of cash.
Stacks of cash. But that's not all. It also lists diamonds.
And specifically loose diamonds.
Yes, that's a crucial distinction. Loose diamonds are not jewelry for adornment. They are a high-value, portable, and utterly untraceable form of currency.
It's a universal currency that doesn't rely on the banking system.
Exactly. Finding loose diamonds in a safe suggests a contingency plan. A plan for a scenario where your assets are frozen and you need to move wealth discreetly.
And then there's the passport.
The passport. This might be the single most important item found in that safe when it comes to assessing his intent.
An Austrian passport. The memo says it was expired, but it was found in the safe.
And here's the discrepancy noted in the filing. The photograph on the passport was Jeffrey Epstein.
But the name was not.
The name was not Jeffrey Epstein. It was a false name. And the place of residence listed on the document was Saudi Arabia.
A fake identity document with his picture locked in a safe with a hoard of cash and untraceable diamonds, listing a residence in a country with a very complex extradition relationship with the United States.
The prosecution argued this was essentially a flight kit. It's forensic proof of capability and intent to flee. This isn't a souvenir someone keeps. It's an operational tool.
And they used this to argue against bail. They cited his net worth, over $500 million, plus this passport, as proof that no amount of bail could guarantee he'd show up for trial.
It made the flight risk argument almost undeniable for the judge.
The raid inventory also mentions something else. The photographs.
It does. The bail memo notes the seizure of mass quantities of sexually explicit photographs of what appeared to be young women.
So this corroborates the victim testimony, the claims that he would photograph them.
It moves it from a he said, she said scenario to we have the pictures. It's physical corroboration of a key component of the victim's stories.
So you have the charges, you have the physical evidence from the raid, but the entire case really hinged on getting past the 2008 immunity deal.
The non-prosecution agreement, the NPA, that was the primary shield for the defense. They argued it gave him a blanket immunity from federal prosecution for these crimes forever.
Which brings us to the next block of evidence, the new victims coming forward.
This is where the SDNY's legal strategy really shines. After the arrest on July 6th, the floodgates opened. We see this documented in reports from Business Insider and the NY Daily News at the time.
Over 20 new accusers came forward in just the first few weeks.
A surge. And the SDNY's job was to carefully differentiate between the victims who were known to prosecutors back in the Florida case, the NPA-era victims, and these new women coming forward, the 2019 indictment victims.
And that distinction is the whole ballgame.
It's everything. The SDNY's position, which is documented in their filings, was that the 2008 agreement could not possibly grant immunity for crimes that were actively concealed from the Florida prosecutors at the time.
So if a victim wasn't on the Florida investigators' radar back in 2008, the deal doesn't apply to her.
That was the argument. You can't get immunity for a crime nobody knew you committed. And what strengthened their position was the incredible consistency in the new testimonies.
The Jane Doe witnesses.
Yes. When you cross-reference their accounts, you see the same variables repeating over and over again.
Yeah.
It's what investigators call independent corroboration.
So two women who have never met from different states, different years, describing the exact same non-public details.
Precisely. They describe the layout of the massage room in the Manhattan mansion, the specific type of furniture, the color of the walls, details you wouldn't know unless you'd been there.
They also described the same individuals being present.
Right, specific recruiters or assistants. Ghislaine Maxwell's name comes up repeatedly, as do others who were named in the civil suits. They describe the same methods of control.
And the same payment methods?
Always cash. Always in an envelope. Handed over at the end. The consistency across dozens of new independent accounts created what you could call a corroboration threshold.
A weight of evidence.
A weight of evidence so heavy that the SDNY could confidently walk into court and argue that these were credible allegations of crimes that had never been adjudicated in 2008, and therefore the NPA was irrelevant.
So that's how they built the case to withstand the NPA challenge. Let's talk about the operation itself, how they physically got him, the scope of the investigation.
For that, we have to look at the U.S. Marshals Service records and the internal Department of Justice files.
These show it wasn't a sudden decision.
Not at all. The agency coordination was significant. You had the Southern District of New York prosecutors, the FBI, the NYPD, and the U.S. Marshals all working together.
And the report of investigation dates confirm this. We see activity ramping up in June and early July of 2019, right before the arrest.
It shows a planned, deliberate operation, not an impulse, which brings us to the arrest itself. July 6, 2019, at Teterboro Airport in New Jersey.
The arrest warrant, the AO 442 form, and the process receipt and return document the logistics.
They do. They confirm Epstein was returning from Paris on his private jet. And the tactical decision was made to arrest him the moment he stepped off that plane on the tarmac.
Rather than waiting for him to get back to the mansion.
Right. And that choice is very telling.
It implies active surveillance. They were tracking his plane.
Without a doubt. It establishes that law enforcement knew his exact movements before he landed. They were waiting for him. It's a standard tactical choice for a high-value target. You arrest them at the airport for two reasons.
One, to prevent them from getting to their residence and destroying evidence.
And two, to prevent them from being tipped off and diverting the plane to a non-extradition country. You take them into custody in a controlled environment before they can react.
And the internal emails from the DOJ's pinpoint database show this wasn't a new investigation?
Correct. We can see email chains with subject lines like RE-SDNY investigation that date back into 2018. This is a long-running covert grand jury investigation.
The emails show the prosecutors involved, Maureen Comey, Jason Swergold, Allison Nathan.
It verifies that this was a priority case within the office well before the public had any idea.
And those files also show a certain amount of tension, a legal carefulness.
Yes. There are notes in the case files about the handling of STFL materials, Southern District of Florida versus SDNY materials.
They were building a firewall.
A complete firewall. They were meticulously separating their new 2019 evidence from anything connected to the tainted 2008 Florida case. They knew the NPA was the biggest hurdle, so they built a case that didn't rely on anything from that original investigation. They were ensuring the failures of the past couldn't legally poison the new prosecution.
But that still leaves the biggest question, the gap. Why did it take so long?
13 years.
Which brings us to the timeline reconstruction. There's a document from 2006 from the very beginning of all this, that is. It's just extraordinary.
The letter from Palm Beach PD Chief Michael S. Ryder, dated July 24, 2006.
And in this letter, the chief of police who ran the original investigation says, point blank, I do not feel that justice has been sufficiently served.
That's the origin point of the institutional failure. In 2006, the head of the local law enforcement agency is putting it in writing. He's officially dissenting from the outcome.
And yet, a 13-year gap follows. 13 years of institutional inaction between that documented warning and the 2019 federal indictment.
And for years, the question was just, why? What happened in those 13 years?
And a document that came out in 2025 starts to provide a possible answer. The 2025 DOJ release of the correspondence between former Florida Attorney General Pamela Bondi and FBI Director Kash Patel.
This correspondence documents what can only be described as a missing timeline. AG Bondi, as part of a review, formally requested the full and complete files on the Epstein case from the FBI.
And the FBI's initial response?
The initial response documented in this letter was 200 pages.
200 pages for a multi-decadal international sex trafficking investigation.
It's a statistical impossibility. It's a number so low, it's an immediate red flag. A routine traffic accident investigation can generate more paperwork than that.
It indicates a record being withheld.
And the letter confirms that suspicion. It goes on to detail the subsequent discovery, the revelation that the FBI's New York field office was holding thousands of pages of investigative material that had not been disclosed in that initial response.
So not 200 pages, thousands, sitting in the New York field office, undisclosed to the Attorney General's inquiry.
This is a massive forensic note in the timeline. It confirms that whatever was happening publicly, internally, the record was either grossly mismanaged or it was being intentionally compartmentalized.
A silo.
A silo.
Huh.
We don't have documentation for intent, but the result is documented. If the New York office has thousands of pages that the main FBI and DOJ don't seem to have access to, that's a fundamental breakdown of information sharing.
Or it means the SDNY prosecutors who finally brought the 2019 case may have been working with an incomplete record themselves for years.
That is a very real possibility. We have a documented discrepancy. The official file was said to be 200 pages. The actual file was thousands of pages. That fact changes the entire context of the 13-year delay.
So let's look at the institutional decisions that were made based on the information they did have access to.
Right. And one of the biggest fights the SDNY had was simply getting information that already existed but was locked away.
The SDNY denied sealed records filings.
These documents show the prosecutors battling to get access to the sealed civil court records from the Joffer v. Maxwell case. Those files contain key depositions, witness lists, evidence.
And the timeline is important here. The unsealing of those documents, which was ordered by the Second Circuit Court of Appeals, happens right around the same time the 2019 indictment is finalized.
It was a critical decision point. The unsealing allowed crucial evidence from the civil system to cross the barrier into the criminal system. It likely provided the final pieces the prosecutors needed.
And their prosecution strategy itself was a key institutional decision, the choice to charge conspiracy.
That charge is a powerful tool for prosecutors. It allows them to include acts that happened outside the normal 5-year statute of limitations, as long as they can prove the conspiracy was ongoing and continued into a more recent time frame.
So the SDNY documents frame that 2002-2005 period as just the start of the conspiracy.
Exactly. They argue the conspiracy to traffic minors continued well beyond 2005, which justifies bringing charges for those earlier acts in 2019. It's a way to hold him accountable for a long-term pattern of behavior.
There's another indictment from this period that's relevant, not of Epstein, but of the people guarding him.
The correctional officer's indictment. The indictment of guards Tova Knoll and Michael Thomas.
And while the details of his death are for the next deep dive, this document is crucial for establishing the institutional environment he was placed into.
It documents a catastrophic operational failure at the Metropolitan Correctional Center. The indictment lays out, in black and white, the falsification of official records.
The guards' logs said they made their required checks on Epstein and other inmates in the special housing unit.
But the video evidence, which is cited directly in the indictment, proved they were not making those checks. They were sleeping or browsing the internet at their desk.
It establishes a documented pattern of record falsification within the very institution tasked with holding him. If the official logs from a federal prison are proven to be fiction, then the official timeline of anything that happened inside that prison becomes fundamentally unreliable.
And that unreliability hangs over everything that comes next.
Which leads us to the final evidence block. The unresolved gaps, the things the documents show us, are still missing.
The biggest one is the network gap. You see it when you compare the names in the 2019 indictment against the names in the Epstein flight logs and contact lists that have since been released.
The indictment is laser-focused. It names Epstein and later Ghislaine Maxwell.
It is a vertical prosecution targeting the leaders of the conspiracy. But the flight logs and the infamous Black Book show a horizontal network, a vast list of powerful and connected people. Hundreds of them. The indictment does not charge the powerful men who are documented as flying on his plane, visiting his island, and who were alleged by victims to have participated in the abuse. We have documentation of presence, but a documented lack of prosecution for these ancillary figures in the 2019 federal case.
The indictment targeted the suppliers, not the clients.
That's what the record shows. And then there's the declassified gap, which goes back to that Bonnie Patel correspondence.
Right. The Phase 1 release of documents from that review mentions sexual exploitation of over 250 underage girls.
250.
Yeah.
That's the number cited in an official DOJ review.
But the 2019 indictment cites a much, much smaller number of specific victims to make its case.
So the factual question the documents leave us with is, where are the case files for the other victims? If the government has evidence of over 250 victims, but only builds a case around a handful, what happened to the evidence for the rest?
And where are those thousands of pages from the FBI's New York field office?
We have no documentation confirming where they ended up, or if they were ever fully integrated into the prosecution's case. We know they exist. We don't know what's in them.
So let's synthesize this. Let's review the pattern the documents prove.
Fact 1. The 2019 SDNY indictment was robust and evidence-based. It cited specific criminal acts, a financial payment structure, and was backed by significant physical evidence from the mansion raid, including the cash, the diamonds, and the fake passport.
Fact 2. The prosecution's success hinged on legally and factually overcoming the 2008 non-prosecution agreement. They did this by using the testimony of new victims whose accounts were independently corroborated.
Fact 3. A massive documented discrepancy exists between the FBI's initial disclosure of its case file, just 200 pages, and the thousands of pages that were later discovered to be held by the New York field office. This suggests, at minimum, a severe institutional breakdown in information management.
And fact 4. The fundamental mechanisms of the abuse, including the pyramid recruitment scheme, were known and documented by law enforcement as early as 2006 per the Palm Beach police chief's letter. But they were not acted upon at the federal level until 2019.
The documents prove a valid, evidence-heavy indictment was filed in 2019. What remains unproven is why it took 13 years to file it, and what is contained in the thousands of pages referenced in the 2025 audit.
Next time, the first suicide attempt.
You have just heard an analysis of the official record. Every claim, name and date mentioned in this episode is backed by primary source documents. You can view the original files for yourself at epsteinfiles.fm. If you value this data-first approach to journalism, please leave a 5-star review wherever you're listening right now. It helps keep this investigation visible. We'll see you in the next file.